Hello, good evening, friends. Welcome to today's session. If you remember, in the last session, we could not complete the topic, but when I was going through today's session, the contents, I found that they are in continuation. So we are not going to miss anything. Of course, there's no question of missing when we abruptly stop somewhere and then start again from the same slide or from the same content. But yes, a brief recap of what we learned yesterday. It was about the various definitions, various terms which we use while in the formation of a contract. So we have not yet reached that stage. Before we reach the formation of the contract, what is contract and what are its features? We have not yet reached that stage, but to reach that stage, that position, we have to learn a lot of terms and the application of those terms in various circumstances. So we first started with a offer in English law and a proposal as per Indian Contract Act, Section 2A. Now there itself we had to spend a lot of time to understand what a proposal is. And not only that, how a proposal is taken under different circumstances. And we were still at that stage. So quickly we'll go through the various stages of proposal. And yes, a proposal or an offer, the word comes from propose. चलो अगली स्लाइड पे चलते हैं so that we have a lot of free space. So proposal फटाफट एक बार देख लेंगे, then we will proceed further. To propose, that means it is conveying, oblique, signifying, oblique, communicating, what? Willingness, willingness to do or abstain from doing something. Proposal is we are just, analyzing it quickly before we go further. Conveying, signifying, communicating, willingness to do or abstain from doing something from one person to another with the purpose that to obtain the assent of the other, this other, right? So you can, it's a breakup of Section 2A. Conveying, signifying, communicating willingness to do or abstain from doing something from one person to another in order to obtain the assent of that other. Right? Now, what is important? We have been going around a couple of situations One thing is that what is very important is it has to be conveyed, communicated. Section 3 and Section 4. Section 3 says what communication is, and Section 4 says when it is complete. Willingness on part of one person to do something, this one person, that is his willingness. I want to sell my watch to you for 1,000 rupees. Is my willingness to sell my watch to you for a consideration of rupees 1,000. Now, the purpose of conveying this or making an offer or a proposal is to get the assent of the other person, whether yes or no. If it is no, matter is over. Right? If it is yes, it becomes promise. That is under Section 2B. Isn't it? Right? अगर उसने मना कर दिया, खत्म. हाँ कर दिया, that means now it is no longer an offer, mere offer or a mere proposal. It has become a promise. Right? And then Section 2C also, the person who makes the proposal is called the promiser and the other person is called the promisee. We can also call offerer or offeree. These words we will be using very frequently now, especially in today's session. Okay, so this is a quick recap of what we did yesterday. Now today let us start with where we left yesterday. Specific and general offers. Right? So we know what is an offer. So what is going to be a specific offer and what is going to be a general offer. As the name indicates, specific means to a specific person. सीधा सीधा मतलब निकाल लेते हैं. Specific offer is from one person to a specific person, one person. But if it is to a large number of people, it's a general offer. So आप कहेंगे, अरे, in the case of general offer, how it will be converted into a promise? If it is made to general public, to everybody around us at large, whosoever will accept it, क्योंकि ultimate aim of an offer is to get the assent of the other, उससे हाँ करवानी है. जिसने हाँ कर दी, the person who has accepted it, accepted the offer, only he will be the promisee who will be making the promise. Right? Suppose now, today yesterday we started with, Carlyle case, smoke ball wala, if you remember, influenza, smoke ball, even Ralman Shukla. Yes? Offer is made to the public. Anyone who performs that, accept us by performance, yes. And then you can mention Section 8 also, you can refer to that. Acceptance by way of performance. So if you perform the condition, now merely performance will not amount again to acceptance. You have to fulfill all the conditions of the offer. Suppose it's a conditional offer and you have performed only a part of it. It will not be. Acceptance has to be in complete form, in the desired form. Today we will be discussing acceptance, but let us quickly go through the special and general offer, which is very simple. I think by now it should be, you must be feeling little bored by my repetitions. हो जाता है ना कि बार बार सब तो एक ही बात बोलते जा रहे हैं. अरे भाई इसलिए बोल रहा हूं कि it should get registered in your mind. Right? So when the offer is made to a specific or a certain person, it is known as a specific offer. But when the same is not made to any particular person, but to the public at large, it is known as a general offer. Very, very simple. Chaliye. Again we come back to the same case. I told you yesterday also that this case will be repeated once again. And today we are going to do that again. The defendants advertise, ये मैंने सारा आपको facts I have already told you, so I will not be repeating it. Yes, yesterday I think I said 1,000 pounds sterling, but it was 100. But it doesn't matter. It is basically consideration. Amount is like consideration, so it doesn't matter whether it is 1,000 or 100, because again I tell you, in civil services examination, they are not checking your knowledge of the facts. They are testing the principle behind it, whether you know it or not, and with how much depth you know it, clarity you know it. Clarity is more important than just mugging up the facts. In fact, I am totally against mugging up of the facts. Even if you don't remember any facts, it's not going to make any difference to your answer. But if you forget even a small part of the principle involved, you will get a big zero. इतना याद रखिए. और अगर आपने principle ठीक लिख दिया, if your answer is containing the principle, even in a couple of sentences, you will get full marks. चलिए. So they announced this. Now, here in this case, yesterday I told you about the intention. We were talking about the intention, if you remember. Now, in this case, how the judges ascertained the intention of the company was, pharmaceutical company was, because of this sentence. They also announced that a sum of pound sterling 100 had been deposited with the Alliance Bank to show their sincerity in the matter. That shows how strong is their intention. Sincerity, that look, it's not mere a promise in the air. We really mean it. So that shows this, and this will come in the judgment also. The plaintiff, relying on this, she still got the. Now, in another important part in this case is that she used it in accordance with the directions of the defendants. That means she fulfilled all the conditions while performing. Performance was not merely using that medicine. It was as per the defendant's conditions. If you have to use it 3 times a day, she used it for 3 times a day, or whatever was the condition. This is clear from this. So if you analyze this case looks very simple, but this case has got a great importance as far as general offer is concerned and performance, acceptance by performance is concerned. This case for so many years still being taken as a landmark case and being followed by all the courts. Though it's an English case, still in India, yes. Now, what are the 2 important things? One is the sincerity by way of depositing 100 pounds in the bank. Second, performance in accordance with the directions of the defendant. She sued the defendants. It was held that this being a general offer, addressed to all the world had ripened into a contract. What do you mean by ripened into a contract? A contract develops. जस्ट अभी यही समझो, आगे का मत जाना, क्या एग्रीमेंट होता है, क्या कॉन्ट्रैक्ट होता है, क्या वाइड होता है, क्या वाइडेबल होता है, बाद में we'll all study maybe tomorrow. But just in your mind, the legal relationship which we talked about yesterday comes into being when there is an offer and there is an acceptance which becomes a promise. The moment 2A and 2B are complete, you get a legal relationship. And this here we say ripened into a contract is, that means the legal relationship is established. With the plaintiff by her act of performance of the required condition and accepting the offer. So acceptance by way of performance of the required conditions. This is how you must analyze such cases so that each and every ingredient of the law is fulfilled. Right? This is the way you have to analyze any. Suppose this whole situation is given in the form of a question, and that is exactly what the examiner will be doing. So, as per my, instructions to you earlier, underline. So here you can underline that this is a general offer, ripened into a contract by way of performance of the required conditions, thus acceptance. So this general offer becomes a promise on acceptance by performance of all the conditions. If you write one single sentence, your answer is complete, even if it is in 10 words. Chaliye. She was therefore entitled to claim the reward. Now, in this case, Lord Justice Bowman says, it is an offer made to all the world, and why should not an offer be made to all the world, which is to ripen into contract with anybody who comes forward and performs the condition. He asked this question, why should not be so? If anybody comes forward, so there is nothing wrong with the general offer. Suppose you face a question, is general offer acceptable under the law of contract? You can say yes. Why? Because if anybody from the world at large to whom it is addressed comes forward and performs the condition, it will ripen into a contract. It is an offer to become liable to anyone who, before it is retracted, this is what today we are going to learn. What is retracted? Vapas le lena. Suppose you have made an offer and before it is accepted, please remember this. Once it is accepted, it becomes promise. But before it culminates into a ripened, into a contract by way of a promise, by way of acceptance, you can withdraw it at any time. Note कर लीजिए, आगे अभी आएगा. Performs the condition, and although the offer is made to the world, the contract is made with that limited portion of the public who comes forward and perform the condition on the faith of the advertisement. Advertisement is nothing but a manner of conveying, signifying the willingness of the person who is seeking your assent for that. Chaliye. Then we come to standing, open or continuing offers. What is a standing offer? What is a continuing offer? नाम से पता चल जाना चाहिए. Which is not made only for one instance. It continues till it is accepted. कहते हैं ना, I gave you standing instructions. Government gives us standing instructions regarding COVID. Standing instructions are what? Wear masks, right? Have social distancing, maintain hygiene. These are standing instructions. When you get into metro, you have to be sanitized. I don't know because I don't travel by metro, but suppose this is a standing instruction. It will continue till it is either withdrawn or its form changes in the form of a contract or a promise. An offer which is allowed to remain open for acceptance over a period of time is known as a standing, open or continuing offer. Now, can you give me any example of that out of your own experience, out of your own understanding? Any example of a standing instruction? Yes, somebody said tender. Anything else? Tender is slightly complicated in the sense because tender is a very general word. I'll give you, right now I'll give you, based on your tender only, I'll give you another example. Anybody else? Job vacancy. Job vacancy, do you call it an offer? Is it an offer or invitation to offer? Supplying milk to a sweet shop over a year. Very good. Very good example. Very good example. I place an order to my milk vendor. Anubhav has given a good example. Order to my milk vendor for a year. Right? You will supply 2 liters every day. मैं थोड़ा ज़्यादा दूध पीता हूँ इसलिए 2 लीटर ले रहा हूँ. 2 liters every day for 1 year. This is my order. Now, each and every supply will be a separate contract. We will see in different cases. You get a government order, not a tender, I'll say a government order, which is called GO, placing you orders for supplying, let us say, these ball pens to that department at the rate of rupees 10 per pen for 6 months. Now, every time an order is placed and a supply is made, that will be a separate contract. Now, this order can be cancelled, can be withdrawn in between during that period, 6 months period, any time. You may say, yes, bhai, main ab aur nahi de, provided there is a penalty clause or no. But yes, That's what I am saying. We can cancel an open offer. An offer can be cancelled, revoked, accepted any time before its time period is over. That we will see in a number of cases. How this tender and acceptance. Today's topic is on that only. But this is how to give you an idea about an open or a standing offer. But for that offer can be for the entire quantity or it can be for each quantity which is ordered periodically. Buy one, get one free, only available for 5 days. Transportation of money from RBI to different. These are different kinds of orders, right? ठीक है, चले आगे. If delivery of pen is made today and tomorrow, so the delivery of today and tomorrow will be separate contract. Yes. Each order, each supply will be a separate contract. Each. That is why if today you have supplied, tomorrow you have failed to supply or you refuse to supply, there is no breach of contract. We will see. I'm just giving you an inkling about the whole thing. Acceptance of a tender for the supply of goods is a kind of standing order. आ गया? ठीक है? An advertisement inviting tenders is merely an invitation for quotation. This is where you can draw the difference now clearly. After yesterday's discussion on invitation to treat or invitation to offer. When the tender is approved, it becomes a standing offer. It is not an order. It is a standing offer. As and when an order is placed on the basis of the tender that amounts to acceptance of the offer and results in binding contract. So each and every order, that means what is that called? That is called as a supply order. So each supply order will be a separate contract. Such an offer may be revoked or withdrawn before the order has been placed. Even though the offer is originally made open till a particular time, it may be revoked earlier than that, may revoke it at any time before its acceptance. So, before acceptance, offer can be revoked at any time. The defendants agreed to supply coal to the plaintiffs up to a certain quantity at an agreed price for a period of 12 months. As may be required, look at this, as may be required by the plaintiff from time to time. The plaintiffs placed orders for the supply of some coal and same were complied with. Before the expiry of the said period of 12 months, the defendants withdrew their offer to supply further coal and refused to comply with the orders placed thereafter. They were sued for breach. It was held that there was no contract between the plaintiff and the defendant, and therefore there could be no liability for breach of contract. Is this point clear to you or not, this concept? Please, this is very important. I tell you, yesterday also I repeatedly told you that the difference between offer and invitation to offer is, the line is very thin, but it should be now clear, this dividing line. and then offer is open till either its acceptance or revocation. हाँ जी, बताइए.
Last time, it may be revoked earlier than that, may revoke it at any time before its acceptance. तो मतलब एक बार एक्सेप्ट में हो जाएगा तो फिर वो रिवोक नहीं कर सकते.
एक्सेप्ट हो गया तो कॉन्ट्रैक्ट बन गया. हाँ.
लेकिन सर मतलब तो कंटिन्यूइंग ऑफर है सर, ऑफर तो अगर ऑफर भी चाहे तो भी आपके तो एक्सेप्ट कर सकते.
जब तक एक्सेप्ट नहीं हुआ है कोई भी आके ओपन ऑफर को एक्सेप्ट कर सकता है. हाँ. अगर मान लीजिए, that's what I said, any member, what the judge also said, that any member of the public who comes forward to accept it, either directly or by way of performance, या तो परफॉर्म करके एक्सेप्ट करेगा या वो सीधा एक्सेप्ट कर लेगा. Right? If I offer my watch for 1,000 rupees and you come and say, yes sir, I accept it, our contract is over. But if I say, if anybody who will complete this paper, I give you a question, any one of you sitting in the class can complete this paper in 10 minutes, I'll give him 100 rupees, 500 rupees, 1,000 rupees. So, जो कर लेगा, he has accepted the contract. And if I go back on my word, it is breach of contract. Yes, please. How there was no contract in this case? Which case you are talking? No. Again, you are getting confused about the difference between offer and invitation to offer. Please, मैं दोबारा से समझाता हूँ, because I don't want even a single one of you to get confused or have any doubt. What is invitation to offer? भैया चाहे 10 क्लास लग जाएं, बेसिक समझने हैं कॉन्ट्रैक्ट की, अदरवाइज पढ़ाने का कोई फायदा नहीं. देखिए, व्हाट इज इनविटेशन टू ट्रीट और इनविटेशन टू ऑफर. लेट अस टेक द केस, बिकॉज टुडे वी आर टॉकिंग अबाउट बंगाल कोल कंपनी. यस, without naming any case, I'll say if there is a tender, tender is doing what? By way of tender, the tenderer, the person who is floating the tender, it may be a government organization, it may be a private organization. In the case of Bengal Coal Company, it is a private contract. Now what happened? They float a tender. What does that tender say? That says, we invite bids or offers or sealed tenders or quotations. Different names are there for the supply of 10,000 tons of coal in 12 months in our factory located in Gurgaon. Chalo, just read it. Read it. This is only and what? We invite bids, offers, sealed tenders, quotations, etc. It may be an open tender also for the supply of this much quantity of coal for period 12 months at our factory in Gurgaon. This is clearly what? Invitation to offer. Now, offer will come in the form of bids, offers, sealed tenders, quotations. Those bids, those tenders, those offers will be known as the offers. ये बात समझ आई कि नहीं? So the offer starts with what? The bid, not with the tender.
This line acceptance of a tender or the supply of goods is a kind of standing off.
Yes, yes. I'm coming to that. Why it is standing offer? बस अभी वही बता रहा था मैं. हाँ, देखिए ये क्या है? ये इनविटेशन टू ऑफर है. डू यू ऑल एग्री? बताइए.
Yes, sir.
My friend here says yes. Yes, you all say yes. Thank you. So this is invitation to offer. In response to the invitation, what has come now? What has come now? Offer. Now this offer is for how long? What is the period? Time period of supply. 12 months. Time period of supply is 12 months. That means what? This offer is open, continuing, standing for a period of 12 months at a price of 1,000 rupees per ton. 10,000 ton is the maximum quantity. A quantity which has been indicated by in the invitation. Now it is an offer. Suppose there is another offer by another tenderer for 900 rupees per ton for the same 12 months. Now he becomes the lowest bidder. Right? So that bid is accepted. Now this 900 rupees per ton for 12 months per metric ton for a period of 12 months is what? It is the offer, but it is, since it is for more than one exchange. अगर एक बार होता भाई ये बताइए, you have to supply me 5 liters of milk today, now, right? This is an invitation. The milkman says, I will supply 5 liters of milk for 20 rupees per liter. That means 100 rupees. This is only one-time transaction. He supplies 5 liters, I pay him 100 rupees. Contract is over. One-time transaction. But here, it is a continuing transaction. The time period is mentioned, overspread over a period of time. So 12 months. And then it will become a standing offer, open offer. Now suppose for the month of October, the coal company or I placed the order that supply out of the 10,000 tons was the maximum limit. He is the offerer. He has offered. Now I place an order, a specific order. For supply of 1,000 tons at the rate of his quoted price of 900 rupees. This is for the month of October. And I specify that this is only for the month of October, supply by 15th of October. Now this is what this specific order is a contract. So for each supply, each order will be a separate contract. Do you understand this now? Each order will be a separate contract because there is a standing offer, and from that standing offer, if you take a piece of it, accept it, and place the order, that will be only one contract. For other months, it is still a standing offer for 11 months. Now for November, you may cancel you may remove, you may say, no, I do not need any supply. Or the tenderer may say, sorry, the bidder who has bid for 900. Suddenly, coal prices have gone up. I can't supply at 900 rupees. That means he is revoking. So it is not a breach of contract because contract has not taken place. There can never be, yes, there can be a breach of contract once the order is placed. If I place the order for October at the quoted rate of 900 rupees, that means I have accepted the offer, but for only a limited quantity. If I fail to take the delivery or if he fails to supply, there will be a breach of contract. But not for the rest of the 11 months, because for the rest of the 11 months, it is still at the offer stage. Is this clear? और इससे ज्यादा क्लियर तो भैया बताओ मैं कैसे बता सकता हूं? आ गया समझ? Good. Thank you. Yes, if you place an order, it becomes a specific contract. Yes, समझ जाओ. खुला है, बाकी खुला चल रहा है. इट्स ओपन ऑफर चल रहा है, कॉन्ट्रैक्ट हुआ ही नहीं है, तो ऑफर कैन बी विड्रॉन. थैंक यू अनुभव. I feel glad I'm able to make it clear to you people. That's my job. Anyway, chaliye. So there was only continuing offer to supply. They were bound by supply code only as regards orders which had already been placed, but were free to revoke their offer for the supply of coal thereafter. Thank you. This is Madala Tataya case is a landmark case as far as supply of some jaggery is concerned. Same lines, same principle. Only thing is you have to quote this case if a question on this comes. This is a landmark case. So examiner will expect that you will be quoting this case. So that is why same, कुछ नहीं है, आप पढ़ लीजिए इसको, principle remains the same. So the orders for the supply had to be made from time to time. One of the conditions stipulated was that administration reserves the right to cancel the contract at any stage during the tenure of the contract. without calling out for outstanding or the unexpired portion of the contract. अच्छा क्या होता है? Why they have used this word contract? Had they not used this word contract also, there was no problem, because the principle is already there that if there is no acceptance by way of a separate order, it will remain an open or a standing offer. But generally in government departments or even in private sector also, they make it very, very specific that this can be withdrawn or revoked or cancelled at any time during the period of that offer. It was held that the stipulation whereby the appellant could cancel the agreement to revoke the. अब देखिए, when it came to the judgment, what is written? Agreement तो चलो ठीक है, contract और agreement हो जाएगा. Revoke the offer in the strict sense, because it is still in the offer stage. So इसलिए don't get confused by the words. Sometimes the facts will be revealing a different kind of words, but the meaning remains the same. It's a open or a standing offer. So no confusion should be there on this. Another important case is this one, but you can, even if you mention Madala Tataya case, sufficient. Offer containing a promise to keep the offer open for a certain period could be withdrawn. Same principle in different cases. Now, read the last line. The condition that a tender cannot be withdrawn before it was accepted is invalid. So a tender is like a standing offer. This is again a very important case. इसको तेंदु leaves case भी कहते हैं, right? Read the submitted tender and also deposited some security. Generally in the tenders you have to submit some security also. So he completed those terms. Tender was to be opened on 9th April 1969. Before that date, the petitioner made an application withdrawing his tender and requested for refund the tender not to be opened. But the tender was opened, and his being the only tender was also accepted. But look at this first one. ये देखिए, इसको देखिए. Before the date of opening, he has already withdrawn. The petitioner refused to execute the agreement to purchase the leaves. The government sold the leaves to somebody else and then sued the petitioner to recover damages amounting to 25,000 rupees. So one of the contentions of the respondent was that there was a clause in the tender notice according to which the petitioner, having submitted his tender, was not entitled to withdraw. Now, this is very important case from the point of view of what a tender is. Sorry, what a contract is. Contract, by way of contract, the parties create terms and conditions for each other. That means what? In other sense, they are creating a law for each other. What is law? Rights and responsibilities. Rights and responsibilities. You perform your right and you perform your responsibilities. Right? Now here the question basically comes is whether the terms of contract, I call it as a law created by the parties. Because law creates rights and duties, here parties create rights and duties for each other. So law created by the contract. And then there is a law which is there by statute, statutory law, or law created by judicial pronouncements. Right? Out of these, which will prevail? Give me the answer. By your own statutory law. Rishabh says statutory law. Who else? Statutory law. Now, if I agree with you, let us take your position. Statutory law shall prevail over the law created by the parties. ठीक है? So statutory law will prevail upon the law created by the parties. In this situation, what the statutory law says, that you can withdraw your tender at any time before it is accepted. समझ आई कि नहीं? Statutory law says that before an offer is accepted, it can be withdrawn, revoked, but not thereafter. It becomes a binding contract. But in this case, what is the contention of the respondent? That, look, there is a condition in the tender which says, once you have given, the tender was not entitled to withdraw the same. You can't withdraw it. Once you have submitted the tender, you cannot withdraw it. This was one of the conditions of the tender. Now you tell me what will be your decision in this case. बताइए या ठीक है, जरा ये भी बताएं अपने भाई लोग, ये क्या कहते हैं? Which one will prevail? This is how we learn, and learn easily. I mean, in an easy manner, simple manner. जल्दी बताइए, because we have lot of things to cover. We are left. चलिए देख लेते हैं जज साहब क्या कहते हैं. आपने तो कह दिया. It was held that in spite of such a clause, the tender or any offer could be withdrawn, and therefore in the present case, since the offer had been withdrawn, no contract had arisen between the parties, petitioner could not be made liable. हो गया? So Judge Saab has agreed with your verdict. Thank you. So what further you can see? A person who makes an offer is entitled to withdraw his offer or tender before its acceptance is intimated to him. The government, by merely providing such a clause in the tender notice, would not take away the legal right of the petitioner. हो गया clear? It is therefore quite clear that when the tenders were opened, there was really no offer by the petitioner because he had already withdrawn, even if it was a single tender. He had already withdrawn, so there was no offer. तो कॉन्ट्रैक्ट कहां से आएगा? There could be no contract impliedly or explicitly between the parties. अब ऐसे समझना हमने लॉ को भाई लोगों. देखिए, this is the way you must learn law. Held that a person could withdraw or modify his offer or tender before the communication of acceptance was. Now we will be coming to this. ये communication of acceptance वगैरह वगैरह अभी आएगा. Wait for another 5 minutes. So again the same thing has been repeated in this case. Merely providing a clause to the contrary in the tender notice could not take away the. अच्छा, in case you are not able to remember the name of that case, तो वो तेंदू लीव्स केस लिख देना. एग्जामिनर विल अंडरस्टैंड. बस, क्योंकि कई बार नहीं याद आता. ट्राई टू रिमेंबर. यू आर यंग पीपल, मोर इंटेलिजेंट एंड हैविंग मोर मेमोरी देन मी, a poor fellow, but yes, in case that condition comes, write Tendu leaves case. चलिए. Notice inviting tender had no stipulation regarding contract period. Open. Award of contract to respondent who was lowest bidder for 3 years could not be said to be illegal. Mere omission of specifying period of contract in NIT होता है notice inviting tender. You don't get confused. चलिए. NIT provided that vehicle should not be more than 6 months old. As manufacturing of specified vehicles has been stopped during relevant time, hence permitting respondent to substitute that vehicle with another vehicle had was not to be an arbitrary. It's a different story. So now we are coming to letters of intent. Letters of intent का क्या मतलब होता है? No. Law will prevail. You said if parties willingly agree that a specific provision of law will not be applied to the contract, in such a case the intention of the parties will prevail or not. देखिए, जब हम लॉ पे आएंगे ना अपना कॉन्ट्रैक्ट की डेफिनेशन पे, व्हाट इज कॉन्ट्रैक्ट? An agreement enforceable by law. If it is going against the provision of law, you can't enforce it. So as long as there is no breach, there is no dispute, you continue with whatever conditions you have put in the contract. But if a dispute comes and you go to the court for breach of law or breach of contract, the court will say no. It is not enforceable by law. It is not a valid contract. जब तक गाड़ी चल रही है चला लो, पर जब कहीं फंस गया फिर वो you can't enforce it. So I was telling you what is letters of intent. What does the name indicate? Letter of showing your intention. So it is only, let us see, the letters merely set out the terms on which the parties were ready to do business with each other if and when orders were placed and executed. Invitation, intention, invitation. मैं कुछ समझ नहीं पाया. ऋषभ, कैन यू राइट इट इन स्मॉल दिस थिंग? यू आर राइटिंग इन वेरी Okay, let me read it. In case of general offer, okay, suppose a person accepts the condition and starts performing, and in the meantime, such an offer is revoked by promisor. Would then promisor be able to abide by his offer if promisee does the thing he asked as asked in offer? This is what I told you. As long as it continues, you set your own terms. If there is any dispute, revocation is permissible by law. In a standing offer, revocation is always available to either parties. But if there is a dispute regarding that, law will stand by the person who has revoked it, because he has not gone against the statutory law. Do you get it? Very good. Thank you. Now, friends, I will put one situation. Read this Supreme Court here. Letters merely set out the terms on which the parties were ready to do business. Ready to do business with each other if and when orders were placed and executed. Now I am putting one term before all of you. Tell me, what is it? MOU. What do you mean? Memorandum of Understanding. What is Memorandum of Understanding? Is it a contract? Is it an offer? Is it an invitation to offer? What it is? Our friend Mayank says it is a contract. May I ask you how?
So because both the parties they accepted all the terms and conditions there, and it is also enforcing the law.
It depends upon intention of the parties. थोड़ा नीचे करो इसको जरा यार. Intention, एक मिनट पढ़ने दो. It depends upon intention of the parties. Generally, it is an invitation to offer, but if intention is to create a legal relationship, then it would be a contract. Rishabh says that. Then Shashank says invitation to offer. Then Kirti says agreement. Mayank says contract. Abhi karte. Any other person who wants to take part in this quiz? If not, I'll proceed with explaining it. What does the name indicate? It is a kind of understanding between two persons in a written form, which is called memorandum. Does it mean any commitment? Does it mean any offer, specific offer? Does it mean any acceptance or promise?
It depends upon the condition of that particular memorandum.
देखिए, try to understand. Yes, all of you said no, sir. I agree with you. It is no. Now, MOU is an offer. Is it an offer? again I come to you. If it is an offer, offer for what? Offer for what? Tell me. Contract. What contract? What contract? You are further complicating the issue. Offer for contract. ऐसा भी कुछ होता है क्या? Contract is when an offer is accepted, a promise for a consideration. अब MOU है, what condition? अरे भाई आप समझ नहीं पा रहे हो. I am again pointing to this word, understanding. अरे कोई offer, there is no offer between them. What is there? Suppose Ambanis come to the state of Haryana, sit with the CM of Haryana, Honorable CM of Haryana, and say, yes, we understand, we reach an understanding that Ambani, that the Reliance Group, will invest 10,000 crores in Jajjar district of Haryana. Is it an offer? Is it a contract? Is it an acceptance? It is merely an understanding. We agree to invest. They may invest. Where? How much? For which purpose? Industry. Which industry? It is only an understanding. It is just the first process. Look, we understand to work with each other. I sign a MOU with you. We understand. अरे भाई मैं सिर्फ इतना अंडरस्टैंड कर रहा हूं. हाँ, you can be my student. Other things are written in the terms and conditions of our admission form. And my admission form is an offer to you. Once you sign it, it becomes an agreement, a contract. Memorandum is something which is in written form.
Also, sir, it also describes some conditions.
It is only an understanding. जो हम मुंह से बोल रहे हैं वो हम रिटर्न में लिख रहे हैं. Mukesh Ambani comes to Delhi, talks to Mr. Kejriwal and says, okay, I am realized my company we reach an understanding that we will explore investing 1,000 crores in Bhavana industrial area. That's all. Which industry? For what purpose? How much? It can be 1,000, it can be other. It has no legal backing. It is no contract. It is not even an offer. It is merely an understanding which has been put into writing. Very important to understand. भैया ये समझना बहुत जरूरी है. No college teaches you this. MOU क्या साइन करवाते हैं यार? उसमें क्या होता है? MOU. We reach an understanding. it is, see, unless and until there is a written offer, suppose you're talking of the bank, it has to be in the form of a contract. If it is only MOU, it is just understanding between you and the bank that we will complete these formalities for a loan to be given to you, maybe a house loan or a car loan. But it doesn't say we offer you a or this is to certify that we give you this much amount for as car loan or as house loan. Nowhere. पढ़िए आप जाके बात खत्म. So it is not offer. Contract तो बहुत दूर की बात. Not even an offer. It is merely an understanding which has generally, yes, you say do MOU precedes an offer. Generally, yes, but it is not a precondition that you must have a MOU and then offer. It can be without an MOU also. That is why if you see, so many states come out with advertisements that we had a meeting with the industry's leaders and so many MOUs amounting to 1 lakh crore investments were signed. But after that, few months, even a few years, if you go back to them and say how much has been invested, how many MOUs have been converted into definite contracts, you'll find not even 10%. It is for our poor fellows' consumption. हमें अच्छा एक वो दिखाते हो. No, very rosy picture. MOU signed with Japan, with South Korea. इतने लाख करोड़ का इन्वेस्टमेंट आएगा, हमारी स्टेट में आएगा, हमारे शहर में आएगा. कहाँ? This is what I wanted to tell you. Forget about letters of intent even. Now is the time for MOUs. And friends, I won't be surprised if there will be a question on MOU. Unless you have this much of in-depth knowledge about contract, you will not be able to attempt this question. I can challenge. You can yourself find this answer. When you ask yourself, just about 10 minutes back, when I asked you what is MOU and now what is your knowledge about MOU, कितना फर्क है? Did you understand what was MOU? None of you. None of you here or in the class. Yes. Everybody had his or her own idea about MOU. Contract, agreement, offer, invitation to offer. ये कहीं भी नहीं है. It is nowhere. You can't put it under any category. It is at the most, you can say, maybe a letter of intent. That is why, friends, when I sign any paper with my faculty even, I never sign MOU. All other institutes will be signing MOU. And they feel very elated. देखा हमारा MOU है. So and so, I will not name. Top history faculty, top psychology, top anthropology faculty. We have signed an MOU. बाहर में गया MOU. You go to court and try to, enforce it. I challenge. This is what your understanding should be. Today, when you go back, you talk to your friends who are lawyers or have studied law or law students and ask them this question. Get the answer, let me know tomorrow. Chaliye, as soon as an order was placed and accepted, a contract arose. It is true this contract would be governed by terms set out in the letters, but until an order is placed, accepted, there was no contract. So at the most, you can put MOUs under the category of letters of intent. At the most. Even then, MOU has got a separate meaning, separate scope. Chaliye. A letter of intent, no doubt, may be construed as a letter of acceptance, acceptance if such intention is evident from its terms. But it is rarely done. Very, very rarely done. It is not uncommon in contexts involving detailed procedure in order to save time to issue a letter of intent, communicating acceptance of the offer and asking the contractors to start. Abhi kya hota hai? Why letters of intent are used by agencies even in the government? To save time. Till the time the detailed contract is formulated, a letter of intent is issued by the department to the contractor that the contract subject to the conditions, terms and conditions of the contract to be signed, you start the work. That shows the intention, and that can be taken as a kind of acceptance. And that too for this particular purpose. So in that case, it may amount to acceptance of the offer. Right? Now in this case, letter of intent providing that it would be followed by detailed purchase order, which had an arbitration clause, was not an order for supply, and the arbitration agreement did not come into existence. Arbitration में क्या होता है? There has to be an arbitration agreement. Either it is part of the main agreement, main contract, there is an arbitration clause, or if there is no such clause, there can be a separate arbitration agreement also. We'll study that when we discuss ADR. Okay. Acquiescence did not confer jurisdiction that the existence or validity of an arbitration agreement shall be decided by the court. At some point of time, it had stated that they would appoint an arbitrator. Isme mat jao bhi. We'll see at that time. Okay? So, previous year's questions, friends, we will take up at the end. Let us first complete our content for acceptance also. Okay? So, I will not, though they all have been covered, but still, I will personally feel satisfied if I take up each and every question for your clarification. चलिए यहां से शुरू करते हैं. This is in fact today's session. Acceptance. Friends, yesterday we saw only offer 2A. कल का सारा दिन और आज का आधा दिन we have just spent on offer 2A. ठीक है? अब चलते हैं acceptance पे. You may say 2B says if that fellow gives his assent, it means acceptance. Assent to his offer. But acceptance has many terms, many forms. So 2A says this, 2B says when the person to whom the proposal is made, the important words please underline. Person to whom proposal is made. Because this is where we will be discussing lot of things. Signifies, again the word signifies comes, means communicates. His assent thereto. Thereto means to this proposal. The proposal is said to be accepted. A proposal when accepted becomes a promise. Right? Chaliye. Proposal or acceptance is made in words. The promise is said to be expressed if it is made in words. When the proposal or acceptance is made otherwise than in words, the promise is said to be implied by way of conduct, by way of any other mean other than words. इशारे से हाँ भाई चले चलो बस ये इशारा कर दिया मयंक ने I said yes, done. He gave a proposal, I gave acceptance. This is implied. But if it is in writing, it will be expressed. लॉ स्टूडेंट्स के लिए अब इसको एक्सप्रेस और इम्प्लाइड को समझना मुश्किल नहीं होना चाहिए. द ऑफर इज नॉट बाउंड टू एक्सेप्ट द ऑफर. Very right. If an offer is made by the offerer, it's not binding. He may say yes, he may say no. He is free to reject or make it lapse by non-acceptance. This is another important term. Lapse by non-acceptance. यार ये एसी कम कर रखा है क्या? तो चला नहीं रखा. चलो चलने दो, कल देखेंगे. I'll just remove my jacket. Yeah. So this please mark it because we will be talking about this. Lapse by non-acceptance. We'll come to that. But generally for your understanding, the offer has got two ways to put a time limit. Within a specified period of time, it has to be either accepted or rejected or a reasonable time period. Now, if it is specified, there is no problem. If I send you an offer and I say, please send your reply by Saturday. It is specified time. Before Saturday, you can send your reply. If it is Saturday is over, if I receive your acceptance on Sunday, it will be treated as lapsed. What about an offer which has not specified any time period? Will it be ever going on like that? No, it should be accepted within a reasonable. What is reasonable will be decided from case to case. Because when the word reasonable comes, it is against a very subjective term. You can't say what will be reasonable and what will be non-reasonable. Thus, it is perfectly lawful for a company not to accept the highest bid and to re-auction the goods. Because it is open to the offeree whether to accept it or reject it. Even if they have received the highest bid, they have the option or the right to reject it. Now, A person inviting tenders may not accept a bid if an essential condition of the tender is not complied with. Those who have been dealing with tender processes, let me tell you, it is written in most of the bids, that is, tenders in advertisements, the tender not accompanied by the earnest money will be summarily rejected. So that means the tender, the bid, should have the earnest money in the form which is mentioned, whether in the form of a bank guarantee, a check, a postal order, whatever manner. So it is an essential condition of the tender. If that is not fulfilled, it will be straightaway rejected. A person inviting tenders may reserve a power to reject all the tenders. He may say, any or all can be rejected without assigning any reasons. The person submitting the highest bid cannot have a right to have his tender accepted. So what is the effect of acceptance? The contract is created only after an offer is accepted. It becomes a promise. Before the acceptance is made, neither party is bound. This is important because when we come to section 5, 6, the communication, when acceptance should reach, against whom it is binding, that is very, very little technical but very important, which I want to cover today at least. At that stage, the offerer is free to revoke or withdraw his offer, and the offer is free not to accept the offer or to reject the same. Simple hai, jaldi padhenge. After the offer has been accepted, it becomes a promise to be, which, if other conditions of a valid contract are satisfied, binds both the parties. What is important here is other conditions of the valid contract are satisfied. If this is the condition, it must satisfy the other conditions of the tender. After acceptance, each party becomes legally bound by the promise made by him through the medium of offer. Now here, the medium of communication, we have read, signifies, communicates. Through which medium? It has to be medium which is specified. If it is not specified, then a reasonable kind of a medium. You may say reply by return email, immediate email, revert by email, revert by a detailed letter. ठीक है, रिटर्न बाय फैक्स, और फैक्स का जमाना निकल गया, स्कैन द कॉपी एंड सेंड इट. So it has to be done immediately, and the manner which is provided. Now this is important. Anson says acceptance is to offer what a lighted match is to train of gunpowder. This question has been asked in the civil services. चलिए इसका मतलब निकालते हैं, चाहे टाइम लग जाए कोई बात नहीं, आज समझा के छोड़ूंगा आपको. Tell me, it cannot be undone. हाँ जी, once accepted, it cannot be undone. Yes, very right. You gave the right answer. What happens to a gunpowder? उसमें अगर आपने आग लगा दी, if you have put it on fire, can you get it back? No way. So that means if there is an offer and before acceptance it can be revoked. But once accepted and it becomes a promise, no way to revoke it, and it becomes legally binding on both parties. Same as lighting the gunpowder. Can't get it. अब ये बताइए, अगर ये क्वेश्चन आया है, if this question has been asked in your examination, and what I have written here, if you write even this much, you are going to get, if not 100%, at least 90% marks. इतना लिखना बस. And how many words? Not even 50 words. But you are given the choice to write 150 words, so you can little bit more elaborate it. But this is what you cannot afford to miss. You can write 2A and you can write 2B section. It will add to your quality of the answer. Now, अब बताइए, some of you ask me, sir, we don't get answer writing practice. Arey bhai, then what is this? Rest of the thing you have to write. I can't write answers on your behalf in civil services examination, in the examination hall. But I am telling you what is not to be missed. What is essential for, most essential, absolutely essential for your answer. And this is what is written here. You can add something to it. You may give an example to it. And that will complete your answer. What more do you want from me? It produces something which cannot be recalled or undone. But the powder may have lain until it has become damp. Now, he is adding one more aspect to it. May have lain until it becomes damp. Damp with what? Damp over a period of time. Lapsed. He is adding a new term to it. So you can add this also to your answer. Till it becomes lapse. Lapsing of offer is equivalent to damping of the gunpowder. And the man who laid the train may remove it before the match is applied. Removing is what? Revocation. He can revoke. पीछे हटा ले, उसने तीली लगाने से पहले he has withdrawn it. Similarly, acceptance is like putting matchstick to that. If you don't put a matchstick, gunpowder is like that. So an offer may lapse for want of acceptance or be revoked before the acceptance. Also, offeree may decide to reject the offer by not lighting it. Until an offer is accepted, it creates no legal rights and it may be terminated at any time. So, ये भी add कर दो तो your answer is perfect. You will get, if it is 15 marks question, you will get, if not 15, 14. बाकी handwriting पे. The offer lapses if the same is not prescribed by remaining unaccepted until the expiry of the same is not accepted within the prescribed time, or if no time is prescribed by remaining unaccepted until the expiry of reasonable time. ठीक है, चलो आगे चलते हैं, ये सब हो चुका है. Although acceptance of an offer results in a contract, but a mere agreement to agree or an agreement to enter into a contract itself does not result in contract. Go back to what we learned just now. क्या अभी 10 मिनट पहले what we learned, a very important term, MOU, भूल गए. An agreement to enter into a contract itself does not result in a contract. Got it? अब तो केस भी आ गया भाई. Now you have a case law also before you of 1988, Calcutta High Court. So if a question on the MOU comes, explain what we have discussed, mention this case, your answer is complete. In order that acceptance of an offer can result in a contract, the acceptance must satisfy the following requirements, very important to note down. Acceptance should be communicated by the offeree to the offerer. Because to be says signifies. Acceptance should be absolute and unqualified. Now, friends, I am testing your knowledge once again. If it is qualified acceptance, what it is, you have already learned. क्या बात है? क्या बात है? I am delighted, Rishabh. Counter offer. It is counter offer. भूल गए कल पढ़ा था. मैं कह रहा हूं 100 रुपए में दूंगा, आप कह रहे हो मैं 50 में लूंगा. क्वालिफाइड है ना? It is a counter offer. It is not fresh offer, dear. It is called counter offer. ठीक है? Because it is qualified by a condition. It has to be in the same condition. The acceptance must be to the offer in which it is made without any changes, without attaching any thing more to that, subtracting anything, no addition, subtraction. As it is, it must be accepted. Absolute. कोई गुंजाइश नहीं छोड़नी उसमें. चलिए. Acceptance should be made in some usual and reasonable manner unless the proposal prescribes the manner of acceptance. Very clear. Suppose they say, if you accept, send a check of 50% in advance. होता ऐसे? You place an order, you say, if you accept 50% should be immediately given as advance. So if you don't give the 50%, it is not a contract. So you must, in the manners prescribed in the offer itself, offer में ही बताया गया होगा, how, in what manner it has to be accepted. Acceptance should be made while the offer is still subsisting. If the offer has been withdrawn, acceptance will make no difference. If it is revoked, if it has lapsed, no acceptance. It must be subsisting. Should be communicated. Come to section 3. Yesterday we have already studied. So it should be by any act or omission of the party who is accepting it, so in which he intends to communicate or which has the effect of communicating it. That means in the manner, for a valid contract, the acceptance must be communicated, and moreover, such communication should be made to the offerer, not to any other person. Acceptance must be to the offerer by the offeree. But if the offer itself says, if accepted, communicate to my father, and you communicate to his father, fine. If the offer says so, otherwise it must be communicated to the offerer. Acceptance should be communicated. में देखिए how this the wordings. Just remember my wordings when I go through this. Wrote a letter to his nephew offering to buy his house for this. In the letter containing the offer, it was mentioned, if I hear no more about the horse, it is horse, not house, horse. Now, what is this? If I hear no more, I shall consider the same to be mine at this price. Now, it leads us to one question. Does silence mean acceptance?
It can be implied.
No. It is a straight no. It must be communicated. Silence is no way of communication. If I keep mum, am I communicating with you? अब साइलेंस में कुछ भी हो सकता है. We may say नहीं, I am still considering. Did I ever communicate? It can be expressed or implied. It can be expressed or implied, but that must be mentioned in the offer. How? The manner in which it is to be communicated. The manner could be by action, by conduct, by express words. But silence cannot be any method of communication. Silence does not include communication at all. आप किसी को गालियां निकाल रहे हैं, वो आपको वापस में जवाब ही नहीं दे रहा. खत्म बात, खत्म. लड़ाई कहां हुई फिर आपकी? आप ये तो नहीं कह रहे हो मन ही मन में गालियां निकाल रहा है. ऐसे नहीं होता. चलिए, the nephew did not reply this letter. He, however, told his auctioneer that he wanted to reserve this horse for his uncle and therefore desired that the horse be not sold by the auctioneer. But he is not giving any reply. The auctioneer disposed of the horse by mistake. He sued Bindley for tort of conversion on the plea that Felt House had become the owner of the horse which Bindley had disposed of. Held that since the nephew had not communicated the acceptance, no contract had arisen in this case. Intention of the nephew to accept the offer of his uncle or communication of his intention was not enough to create the contract. Offerer cannot impose upon the offeree a duty to reply, and therefore offerer cannot say that failure to reply will be deemed to be the acceptance of that. So you have to give a reply. Mere silence cannot be regarded as acceptance of the offer. Chaliye. Offer by conduct, which you said implied. Conduct would only amount to acceptance if it is clear that the offeree did the act with the intention of accepting the offer. Intention should be clear from the conduct. So communication must be made by the offeree or his authorized agent, and only offeree can accept the offer. Let us elaborate on it. Very important case, market. Right? He was one of the candidates for the post of headmaster. Board of managers passed a resolution selecting him for the post, but it was not communicated to him. Right? No communication. One of the members of the board who had not been authorized to communicate, acting in his individual capacity. जैसे कहते हैं ना, decision of the board was leaked out to him, but not conveyed to him in the manner it should be. Right? So there can be a last minute slip also. Subsequently, the board of managers met again and decided to cancel the appointment and appoint another candidate. He sued the chairman for breach of held that since the resolution passed by the board was not communicated to Powell by the board or any authorized person on its behalf, it could not give rise to a contract. Right? So, it failed. Another important case, in an auction of the query lease, the petitioner's bid of 1800 was highest. In accordance with the auction conditions, the petitioner deposited the security and the earnest money of 540. The bid was not accepted at the auction. Who was to accept? The higher authority, maybe the collector. But instead of sending the communication of acceptance to the petitioner, the same was wrongly sent to somebody else. Very important case. The officer concerned realized the mistake after the expiry of the period of lease. A demand notice was sent to the petitioner asking him to pay the lease money. The petitioner, on the other hand, demanded refund of his security deposit. It was held that the petitioner's bid, which was an offer, although accepted on file, did not result in a contract as no intimation was sent to the petitioner and received by him. The demand notice for recovery was quashed and the respondent were directed to refund the security deposit. Right? In exceptional cases, the terms of offer may be such that they waive the requirement of communication. So this is again, if it is specified in the, because why? You may say, कि sir, ये statutory law के साथ clash नहीं होगा क्या? Manner of communication, and it may be waived also. In such a case, a certain kind of conduct on the part of offeree may be treated sufficient to create a contract. Some kind of communication, manner may be different. It may not be in the form of a letter or any other thing. Maybe, some kind of abstinence from doing something. If that is so, the contract could be created even without communication of acceptance. This is a condition which you can mention in your answers as to when acceptance, when there can be a valid contract in the absence of communication of acceptance. So you can write this. Now section 8 comes, which we mentioned yesterday when we discussed about Carlyle's case. Performance of conditions of proposal is acceptance of the proposal. Today also we have had a long discussion. By conduct, The Allahabad High Court held that there was no accord and satisfaction in the sense, having made it, it was accepting the money under protest, that is conditionally. Under the circumstance, it was held that the signing the no claim certificate and grant of the receipt amounted to discharge of the contract. It is thus well settled that conduct would amount to acceptance only if it is clear that the offeree did the act with the intention, actual or apparent, of accepting the offer. So the conduct which is expected must convey the intention of acceptance from the offeree. So each case may rest on its own facts. Referring to section 8, if the appellant had accepted the checks and encashed them without anything more, the appellant must be held to have accepted the offer by conduct. Okay, you offer me your, let's say, shop, okay, for 2 lakhs of rupees. Instead of sending you a letter of acceptance, I send you a check for 2 lakhs. You deposit it in your account and encash it. Acceptance by conduct. Implied. There was contract for supply of goods by plaintiff to defendant. Default was made by defendant in making payment. Defendant had made an offer in writing to pay certain amount in full and final settlement of dues. It was shown by the conduct of parties that plaintiff had impliedly accepted and received the part amount. These are all small cases. When is communication of acceptance complete? Very, very important and little bit technical also. Now, in case the parties to the contract are present at the same place, now there are 2 or 3 conditions in this. You know, A is the offerer, B is the offeree. A has made the offer to B. B must accept it to make it a valid contract. Right? Now, A's communication of offer to B is complete when it comes to the knowledge of B. Offer. Knowledge. Section 4. Offer इसने उसको भेजी. He sent his offer to him. Once it comes to his knowledge, the communication of offer is complete. Of offer, I am saying. Now, he accepts it. If suppose they are sitting in front of each other, he accepts, he speaks to him, acceptance is immediate. आमने सामने बैठे, right? Now, this is what is saying. In case parties to the contract are present at the same place, one making the offer and the other communicating the acceptance, both the parties become bound immediately because they have conveyed. It must be communicated. It must reach him, his knowledge. If they are, now take the other case. The problem arises when the parties are at different places and communication of offer and acceptance is made by either post or telephone. Right? Now, let us take the case of post. Today I will do only this much. Tomorrow we'll start with telephone and other cases. Bhagwan Das Khedia case, if you remember, Govardhan Das Khedia, Khemgaon and Ahmedabad. Okay. Now what happens? A is in Delhi, B is in Mumbai. A has sent his offer to B through post. So when it will be communicated to B? When the letter reaches B. Then communication of offer is complete. Right? This is very clear, very simple. Now friends, tell me, if B accepts it, it will become what? A promise, a contract which binds both of them. समझो जरा ध्यान से, please concentrate on my words and my face, my actions. When B accepts, decides to accept, acceptance will bind both of them because it will become a promise or a contract. Now it is still with B. Do you understand this? A has sent his offer has reached him, B has decided to accept it. He writes it in the form of a letter, that is letter of acceptance. How he will send it? If he has to send it by post, he will put it in the post box. इसमें डाल देगा. Once he puts it in the post box, can he withdraw it? No. It is what? It is called out of reach of B. ठीक है? The moment it is out of reach of B, who will become bound? Who will become bound? Everybody says B. A will become bound. Why? ध्यान से सुनिए, मतलब there's no hurry. I tell you, I'll conclude my session today at this. This is very important to understand. Who has made the offer? A. B has accepted. Now it is beyond the reach of B. He has put it in the course of transmission. Now A has become bound. क्योंकि उसकी ऑफर एक्सेप्ट हो चुकी है. He cannot withdraw his offer, can he? Look at from this angle. Can A now, after B has accepted, can he withdraw his offer, revoke his offer? No, he cannot. But B can revoke his acceptance before it reaches A. Are you able to understand this kahani, this story? Very, very interesting, very, very important, I tell you. देखिए, आप अपने दिमाग में सोचिए, प्लीज Apply it took me a lot of time to understand when I was a student like you. Yes, I admit that. But I will tell you the formula to learn it in an easy manner. Put this question to yourself: can A withdraw his offer now once B has accepted it? No. As per law, no. It is so A becomes bound. Right? But B has still got a leverage. It has not reached A yet. So A does not know exactly whether B has accepted it or not. It has not come to him, as it has not reached him. Before the letter reaches A, suppose B picks up his telephone and says, no, your offer is not accepted. Phone rakh diya. Khatam. There is no contract. Even if the letter is in the process of transmission. Is it clear, this concept clear? If you say yes, I will say good night. Bataiye. I just want to hear yes or no from you. If you say no, I'll go back to it again. But if you say yes, I'll put down this pen. Rishabh says yes. Very good. Thank you very much, friends. Thank you very much. Thank you. Thank you. Thank you. Thank you. So, friends, good night. Tomorrow we will start with this. When is communication of acceptance complete? And we will not take touch post. We'll see the case laws and then move on to telephone or other means of communication. Right? Thank you very much. Good night. See you tomorrow.